Over the next few moments, I'm going to be speaking to you about some of the lessons that I've learnt over the past few years when I receive a phone call from somebody saying, I've entered into a joint venture relating to a property and I have an issue. And, your heart just sinks. You're like, well, we're a bit desensitized to it, but their heart sinks when they tell us. So I want to talk about some of the common mistakes that we identify when a client knocks on our door and says, we've got a joint venture problem, a problem with our joint venture agreement. And this can get quite complicated. So I'm a bit like an onion, I'm only going to peel the very first layer. I'm not going to get too complicated. I'm not going to go into clauses and semantics, but I'm just going to talk about things that ought not to be too groundbreaking, but mistakes that happen in any event. So what I'm going to tell you over the next few moments is going to be so obvious, and you're going to be like, well, obviously you would be doing things like that. But it's amazing how many people do not, and how it leads to disputes ranging into a few hundred to a few million pounds, or perhaps more. So joint ventures, very common in the property world. I'm sure, how many of you have been in a joint venture? Just raise your hands. Good. How many of you have been in a joint venture but now come out? Okay. And how many of you found it a very positive experience? Okay. And how many found it a bit of a negative experience? Okay, all right. Well, I mean, almost the same number of people who put their hands up about saying they went into one, put their hands up saying it was a negative experience. But it can be a very positive experience. And quite often, the archetype is cash-rich, time-poor person finds time-rich, cash-poor person, and there you are. Let's go and build a property, or let's go and develop something. And that lends itself to your archetype joint venture. And usually it can work out very well. Why? Because you can have somebody who is there prepared to resource you, and you won't have to go to the banks. And if it works out well, that person can keep investing and keep investing in you and investing in the projects that you want to go into. And it could be very successful. And you do not necessarily have to be highly leveraged through some of the high street or more specialist banks. But why does this sometimes lead to an issue? Why is it that, as many of you have said you've entered into a joint venture, have put your hand up to say that it wasn't the most positive experience? Next slide, please. And I'm not going to have lots of slides, this is the last slide, but it really highlights what I consider as some of the difficulties that we've identified with our clients when they've entered into a joint venture agreement. So the first issue, ladies and gentlemen, is not understanding the purpose. Sounds really straightforward. What is the purpose of the joint venture? Is it to develop a HMO? Is it buy-to-let? Is it student accommodation? Is it for the purposes of an Airbnb? It's incredible how many agreements I've read that does not have a recital at the top or anywhere at the heads of terms talking about what the purpose of the agreement actually is. And if you do not know the purpose, then the chances are your joint venture partner is not going to know the purpose, or at worst, you have different views on what the purpose is, and it may not transpire. And that's when a dispute could potentially arise. So the first thing is being very clear, crystal clear on what the purpose is. Of course, the purpose may change, but factor that in. How can you repurpose that agreement if your first purpose doesn't quite go into place? It should be set out in your agreement. Number two, due diligence. And this is where I like to say you've got to go slightly FBI mode on your partner. Do you know who you're getting into bed with? Not literally, of course. But do you know who it is that you're partnering with? What due diligence have you done? How many transactions have they done? If you are somebody financing the agreement, you don't have a lot of time, potentially. You may be resorting to somebody who's got a lot of time and is going to take the reins and really work on this development for you. But what do you know about that person? How many agreements have they entered into in the past? How many projects have they successfully completed? Have you conducted a CCJ on them? Have you checked whether they've got any judgments against them? Any skeletons in the wardrobe? Have they got assets? It amazes me how many people are prepared to enter into a contract, high-value contract with another party, and that party has nothing by their name. So if something goes wrong and you were to go to court and you were to get a judgment, what would you do to enforce that judgment? So a very easy, cost-effective route to take to do your due diligence before entering into an agreement, do a CCJ check, £10 on Google. I think it's Trustpilot or something. I can't remember the exact name, but it doesn't cost a lot of money. You can do an asset trace. There are plenty of asset tracing agencies, 100 quid, 200 quid. You'll know whether you're dealing with a party that has sufficient assets to make this worth your while if you were to have to go to court. So really get to know your partner. It's so important. It's part of the due diligence in my view, and it's not done enough in my view. And the worst thing is lots of people get into agreements with their friends or families and think, oh, well, nothing's going to happen. And those are always, unfortunately, the famous last words as far as I see it. Number 3, the roles and responsibilities. It's so important that the roles and responsibilities of the joint venture partners are expressly set out. Why? Because, I don't know about you, but property transactions don't always quite go to plan. You think it will be done in a year, maybe 2 years, and it always gets extended. And the problem with extended deadlines is that sometimes interest can be lost by one of your partners. It's happened numerous times. Everyone's really enthusiastic from the outset. As the project starts, there's a bit of enthusiasm, then there's a delay, then there's a hiccup, and then one party all of a sudden just loses interest. And they don't comply with their roles and responsibilities. So in my view, it's extremely important that whichever partner, whichever side of the joint venture you're on, whether you're the financer or you're the person going out there to do the deals, it's really important that you are clear as to what your roles and responsibilities are and what your partner's roles and responsibilities are. Because if they are in breach, that takes us into what the failure to perform clause. If they don't do what they're supposed to do, there ought to be a sanction of some sort. Perhaps they don't get quite the same profits, or they won't get quite the same incentives when you exit eventually. So making sure that there is something in the agreement in the event that your partner will have to think about if they fail to perform their roles and responsibilities. And almost there, finally, conflicts. Lawyers make their money when there is a conflict, and quite often a conflict in relation to the contract. Don't let lawyers line their pockets because you haven't done your homework at the outset, and that's me telling you that as a lawyer. Why not have in your clauses, in your contracts, a dispute resolution clause? Because when there's a breach of an agreement, people think automatically, I need to get a lawyer and I need to go to court, and oh my goodness, that's going to cost me thousands of pounds. But not necessarily. You could build in a clause within your contracts to deal with what happens if there's a dispute. Perhaps it could go to arbitration. The Royal Institute of Chartered Surveyors have lots of experts when it comes to property who are excellent at trying to resolve disputes. Or you may choose to go to a mediator and not have an arbitrator. And those mechanisms are so cost effective, so efficient, that you may not even have to go to court, or in fact, maybe not even have to instruct a lawyer. And you could find a resolution to your dispute. So I really do recommend, if you do or you are thinking about entering into a joint venture agreement, to think about a dispute resolution clause and what happens in the event of conflict. Finally, who's going to be in charge of the day-to-day responsibilities? We're almost there. But what I have noticed with property joint ventures, when you've got contractors coming onto site, is that sometimes they get mixed messages from both joint venture partners. The person who's funding the arrangement thinks that they ought to trump the person who's simply doing all the dog work. And the contractors don't always know who to listen to, and sometimes give up and then just come off site. So being very clear as to who's going to be responsible for the day-to-day instructions, activities, and perhaps putting in a buffer. So if somebody is in charge of the day-to-day responsibilities, they can only authorise up to a certain spending level until they need to get everyone else's approval, maybe £5,000 or £10,000, for instance. So just think about that on the day-to-day basis. And finally, Exit. Unlike other businesses, when you're getting into a joint venture, quite often you're thinking about the end result. How are you going to make your money at the end of it? Are you going to go and flip your property? Are you going to, sell it at auction? Are you going to sell it in some other method? If you're not going to sell it, what's the next step? Are you going to put it as a buy-to-let? If you're not going to do a buy-to-let, are you going to put it on an Airbnb? Are you going to do holiday lets? Are you going to do student lets? It's really important that there is clarity on what the exit is. And if your first line of exit, for example, a sale at 3x or 4x or whatever it may be, won't happen, what is the fallback position? And what's the fallback position from the fallback position? There is no reason why all of that ought not to be codified in your agreements. And even if you're going to sell it, why not have an idea on how much you're going to sell it for? I mean, how many people have I seen enter into joint venture agreements and one party has got a complete miscalculation as to what a property is going to sell for and has completely overestimated it? And there's a breakdown in view as to what they're going to get by way of a return. So being very clear on the exit, in my view, is so important and so obvious, but it's amazing how many agreements leave it out. So that concludes what I believe are some of the common errors when entering into a joint venture agreement. It's pretty basic. We can nail it down to clause by clause, sentence by sentence, but I don't think that's necessary for the purposes of today. If there's one take-home message, please just remember to perhaps get an agreement looked over. You don't have to spend lots of money on it, but just get it looked over. And if you are going to use ChatGPT, and let's face it, people do use ChatGPT, there's no point beating around the bush. If you can avoid spending £1,500 or £2,000 on a lawyer to draft it, you're going to use ChatGPT, but at least get a second pair of eyes on it, because ChatGPT isn't always correct. So that concludes my talk this evening. I'd just like to thank you all very much for listening, and Ajay for having me here, and all the organisers who have organised this really, really well, and hopefully I'll catch you later on this evening. Thank you.